I had wanted to dispel the typical lawyer stereotype today by not wearing a dark suit, but I seem to have blended in with the walls instead. So sorry about that if you can't see me. So basically, you come up with a great business idea, you come up with your business, you start your business, you come up with a product, and way down the line you get your product on the market. How do you stop your competitor just coming along and copying you, and all the investment that you've put in, they just sidestep that by copying your business model, essentially. So there are a number of ways that you can now start to protect your intellectual property to try and stop that later down the line. So we don't have time to go through all the types, but I've put them up here. So today we'll focus on patents primarily, as you're all kind of high-tech businesses that you're developing. As well as patents, there's trademarks. So if you've got a company name, product name, even slogans, catchy slogans to go with it, you can protect them via trademarks. And designs as well, particularly if you're a medical device company that you're going to set up, you might as well think about designs as well as patent protection. Copyright will also arise out of things like your marketing material, and sometimes software. The software code will be covered by copyright. So in terms of registering protection, patents, trademarks and designs, you need to register. You need to apply for that protection. Copyright arises automatically. Some design rights also arise automatically, but you're better seeking protection via registration for them. So why are patents important? You've heard a lot about the investors earlier today and in the talks saying that you need a good IP position. As they said, it helps with reducing the risk. So if you can show that you've got some IP there, you've thought about it, that is good for investors and gives them a bit less risk that later down the line your business is not just going to be copied. They also, patents give you exclusivity. So again, I've said that no one can just copy. And beyond that, they're also a good business tool. So you're probably not going to end up going all the way through and manufacturing yourself. You want someone else to do the manufacturing down the line for you. So if you have a patent, you can license them under that patent as an exclusive manufacturer. So it gives you a way of generating a revenue stream that way as well. So in terms of whether you can actually obtain patent protection, there are a number of things that need to be looked at. And I'm sure you're all aware roughly of what patents are. They cover products, processes, and also uses as well. So in the medical field, you might well be looking at new medical uses of an existing pharmaceutical. You can protect those new uses as well. The main requirements for obtaining a patent are that you're new, you're novel, you're inventive, and you've also got to have sufficiently disclosed your invention. So in return for you getting this monopoly of 20 years, you need to tell the world what you're going to do in your patent application and how you do it. That's the kind of give and take that you have with the patent system. In terms of data, it is increasingly important in the biotech field that you have some data in the application, at least in vitro data, to show that you've actually made some kind of technical contribution. So the patent offices are quite strong on that now. And we'll come on to the balance later on of when you need to file. So for novelty, whether it's new, it's a pretty straightforward test. When you file your patent application, that will set a date, and the patent office will look at anything that's out there before that date that's been disclosed. Normally it will be patent applications by someone else, or it'll be journal articles published in scientific journals. And the way they look at novelty is, they say, is it what you're claiming as your invention exactly the same as what's already out there? So if you say have an antibody and your structure is one amino acid different to an antibody that's out there, that's enough, you're novel. So that's the first bit of the test. You then also need to look at whether you're non-obvious, so you're inventive over what's out there. So there needs to be some kind of gap in the knowledge that couldn't just be filled by routine experimentation. So you need some kind of inventive step, which is why it's called inventive step. It doesn't have to be an advantage. An advantage helps. So if you, say, have found that a combination of two products before that were previously known gives you a synergism that you would not have expected by simply combining them, you can give that as your advantage. But also, it doesn't need to just have an advantage as long as it would not be obvious from what's out there to make that combination. So advantages help, but if it's not obvious, you can also argue that way. It's particularly important that you need to make sure that you don't have any publications of your work, for example, in journals, scientific journals, before you file your patent application, because those could be cited against you. So you need to put procedures in place to ensure that you don't make non-confidential disclosures. So if you're going to disclose information to a third party, it's best to either have a non-disclosure agreement signed or to file a patent application first. In the meantime, so if you're pitching, say, and you haven't got your patent application filed, and a good example from the pitches last year from the winner, Eva Diagnostics, when they talked about their invention, so they pitched their company and said, we have a device for diagnosing anemia. We can distinguish, by using a single drop of blood, we can distinguish between the different types of anemia. And this gives us a more cost-effective way of treating anemia because you're not treating unnecessary symptoms if you can work out which one you need to treat. And so in all of their pitches, they didn't actually say that were pitched to the public. They didn't say how they actually achieved that, how they achieved the differentiation in the diagnosis. So that's an example of one way that you can talk about it in your pitch, but not give too much away. So if you're unsure, come and speak to us, and we can give you a bit of guidance on what you can and can't say. So in terms of the patent application as well, the third step, as I said, it needs to be sufficiently disclosed. So you are getting a monopoly, so you need to tell the world in your patent application how you can do this. So you need to demonstrate at least one way of carrying out the invention. You don't need to give every single way. So say you have a class of compounds that you've found, you don't need to show that every single one is effective in the patent application, because otherwise it'd be about 1,000 pages long. You need to give a representative example. If there are structural differences or things that don't really tie all of them together, you might need to give a few more examples and explain in the application why it applies across the whole lot. As I said, it gives you a monopoly, so you need to put everything in your application. Now, you don't always have all of that information. At this stage of filing, you probably only have in vitro data, maybe some animal model data. So you need to put as much in there as you really can and explain why you believe it will lead to what you're claiming it will. It is then possible, if you've shown it's at least plausible in your application that the invention works, you can then file data later on during the prosecution process while you're trying to get grant of your patent. You can file some more later on. You need to have some data in your initial patent application, because otherwise you're very vulnerable to attack. So it's really a timing balance that if you've got absolutely no data, you probably don't want to file yet. You want to hold off a bit until you've got something that you can put in your patent application. Otherwise, you're likely to get attacked, knocked down by the patent office for not having enough data in there. It is a bit of a delicate balance, and it's one that you need to get right, because if you file too early and don't have enough in there, you could fall down. But you want to also be the first to file your patent application so that someone else doesn't get there first. So that's where you really need to involve a patent attorney early on to work with them to understand the business and find out when is the best time to file the patent application. And I know a lot of the talk earlier on was about getting the most out of it for free, beg, borrow, steal. So that's the beg, borrow, steal process with us is where we advise, you come to us, we'll advise you on strategy, on how to develop that strategy. And then you can decide whether to go ahead with IP protection, different filings. The bit I would, if I can give you one piece of advice that you don't scrimp on, that you don't beg, borrow and steal on, is the drafting the patent specification. You want to get that bit right. You need to get that bit right, because it is very difficult after you've filed to change what's in there, the content of it. So if you're thinking this is a long-term process, it's going to take a long time to get your product to market, you need to sit there and sit down with your advisor, take time over it and think, what bends in the road might there be? What developments might there be? How might my invention change when it becomes a commercial product? How might my competitors sidestep it? Are there easy ways to sidestep? So you need to think about all of that when so your patent application won't just contain what you think is going to be your commercial product. You need to build up around that to try and cover the area that you think reasonably might be designed around, so that you're protecting that as well. So you need to start that fairly early on and don't scrimp on that bit. Once you've got your patent drafted, you can use that in lots of different countries. So it's an upfront cost, but then you're saving yourself money down the line. It's also an iterative process as well, so you might be drafting quite a few patent applications as you develop improvements and things like that. So don't think of it as a one-off. You need to keep reviewing your strategy every kind of 6 months or so, or every time there's a development, to make sure that it's moving with the bends in the road. Just going to quickly go through a proposed kind of filing strategy for a startup, how we normally see startups progressing with their strategy. So what we normally suggest is that you first file a UK patent application and you request a search. The reason we say this is because the UK IPO is very highly respected, and they do very good searches, and they are not expensive at all. So for a couple of £100, you can get your application filed there and searched. And they also issue the search results very quickly, so normally it's about a 3-month turnaround. So this really gives you an idea quite quickly of whether you're novel and inventive, you're likely to be, and whether your idea is likely to go ahead in terms of securing patent protection. It's also important, this 3 months, because once you file your initial application, you're given what's called a 12-month priority period. So in that period, you've got 12 months to basically file further applications, and they can claim priority back. And when you look at what's out there as prior art, they will take the date as that first, when you file your first UK patent application. So you can backdate your prior art. So getting your search back within 3 months gives you plenty of time to look at, do I file elsewhere? So your search results come back positive, then you'll probably think about filing an international application. They call them PCT applications, and that basically gives you the right to obtain protection pretty much in every country of the world that's part of this system. So so you've already bought yourself kind of 12 months by that strategy. You then, with your international application, it gives you another 1.5 years approximately to decide which countries to go ahead in. So this gives you quite a big 2.5-year essentially time delay from when you first filed your patent application to look at your markets, get your funding, and really decide where you need to go ahead so that you're spending your money as economically as possible. So this strategy is one that we normally recommend for startups, and even a lot of the big pharma and that file in this kind of strategy as well. Ownership is a big issue, particularly for if you are coming out of universities, if you have student contracts or PhD contracts with universities. Quite often you will need to look at whether the university owns the IP or whether you actually own the IP. Most of the time it will be the university. So you'll need to talk to your tech transfer department at your university and work with them to find out what you can do about the IP. If you're starting a company, a business, then you might want to get the IP moved, the patent protection patents moved over to you. So you'll need to negotiate with them. You'll need to start the negotiations to find out ownership. You really should do that if you can before filing the patent application, so decide with them who's going to own it, or if they own it, the rights that you can have from that. If you are also looking at doing a joint collaboration with other parties, you need to also agree who's going to be responsible for obtaining IP rights and paying any associated costs with that. Again, you need to establish who owns the intellectual property, who owns the patent application, and yeah, who's gonna pay for that. This all comes slightly under contract law as well, so you may have to negotiate a contract, particularly for joint collaborations, for who's going to be responsible. So we're not specialists in contract law. We can give you some advice, but we'd probably refer you to the guys at Olswang to look at the drafting of the contracts. So yeah, that's basically it from me. If you've got any questions.